Hello. So, for whatever reason, you decided to resign from the office of a liquidator, or you're thinking about that. Maybe it was a conflict among the heirs. Maybe there were some accusations or allegations of bad character against you, and you're just outraged because it's so unfair, and you really wanted to help people there, and it's not even your business, and it's not your problem, and now they put everything on you. Or maybe you just feel that it's too much and it's too burdensome, or whatever the reason. You want to step down. Do remember, you cannot simply just stop doing anything and tell the others, okay, now it's your problem. You are still responsible because your name is there as the liquidator. You have to basically remove your name uh, from the office of the liquidator. How do you do that? First of all, you have to produce your final report. And even if, strangely, you're the only heir and you're the only person uh, to whom you're responsible to produce the report, you have to produce that report. For example, you think that there is nothing much in the estate and you want to give up. Still, first you need to produce that report. Especially if there are many heirs, you have to produce that report and obtain their approval, saying that, okay, we're satisfied with your report, we don't have any other claim against you. And you need to have that in writing. Basically, you need to prepare sort of a contract where you will declare that you're going to resign, and the heirs will declare that they are satisfied with your work and renounce any claim against you for the future with respect to the process of the liquidation, of course. All that should be done before a notary. If you think that you did everything right, but there is already a conflict between you and heirs, and they don't want to accept your report, you might need to go before a court and ask the judge to approve your final report, so that again your responsibility is protected. And finally, when all of that is done, you resign again before a notary so that your name is removed from the register. Usually at the very same time, somebody else, either in virtue of the text of the will or elected by the heirs, is appointed as another liquidator. And once that is over, once all the paperwork is done, then you're okay. You're no longer a liquidator of that particular estate. Uh, there is no just a form that you might simply Google, but it's a good idea to go to a notary. At least we're talking in Quebec. It's a good idea to go to a notary and to ask what should you fill, what information should you provide, how you should proceed in order to make it all right. And again, do remember that among the documents you want, because it's not the document that is like prescribed by the letter of the law, and you might renounce without that document, but then you will have problems. So one of the documents you really need is so-called transaction and release, or quittance, or quittance, something where it will be specifically said that there is no claim against you with respect to all of your actions as a liquidator and your capacity as a liquidator for the whole period where you're responsible, where you were at the head of the estate. And despite the fact that there is no template, or at least like prescribed template for that, such a document should necessarily mention the parties, the short description of the situation, parties meaning you and the heirs, and that they agree that they don't have any claim, that they renounce any claim against you in connection with the liquidation, and that they accept your final report. And do remember that you can even proceed with homologation before a court of that document, and sometimes when the situation is particularly tricky and heated, it's recommended to do so. And then you can breathe out and say to yourself, okay, well, I'm out of all that. But again, as I have mentioned several times already through all those videos. If you think that this situation might happen, it might be a good idea to renounce from the beginning and not even get into the office of a liquidator. Because again, contrary to what many people think, it's not just a formality. It's a lot of work. It's a lot of work and responsibility, very often without pay. As long as you're one of the heirs, for example, it's without pay. And you have your family, you have your job, most probably, you have something else to do. And this, depending on the size of the estate, of course, this might become even full-time job or at least part-time job for quite a long time. So before getting into that, consider it all and then make your decision. Good luck and have a nice day.